In the aftermath of the global financial crisis, Australia's flat steel industry was on its knees. Prices had collapsed, imports were surging, and one company carried the weight of an entire domestic industry on its back. And there was a man who was one of the people tasked with saving it. As a senior BlueScope executive, his job was not academic. It was practical: keep the company viable, keep Australian steel alive, and stop the market from tearing itself apart. He was successful and brought the industry force together to counter the market pressure. From the date of him being appointed as the man in charge, the company's stock price was increased by almost 6 times. But years later, that same effort would land him in enduring court proceedings. He was eventually sentenced to 8 months imprisonment and fined more than $500,000, not for fraud, not for bribery, but for trying unlawfully to influence how competitors price steel. This case is not a story about Batman and Dark Knight. It's a story about where crisis management ends and cartel conduct begins, and how Australian competition laws draw the line with brutal clarity. After an unsuccessful appeal in August 2025, ACCC and BlueScope Steel features one of the most significant competition rulings in recent times. After the global financial crisis in 2008, the Australian flat steel market was flooded with cheap imports, largely from Asia. Demand was weak, prices were falling. Raw steel is produced in one of 3 semi-finished products, known as steel slab, billets, and blooms, which then undergo further processing to create a range of further products. The products of concern in this matter are flat steel products, which are produced from steel slab. BlueScope was the only domestic manufacturer of flat steel, sold steel to distributors, who then sold to builders and manufacturers. It was losing margin and market share. Internally, management wanted to restore discipline to pricing. In September 2013, Mr. Jason Thomas Ellis was appointed as the General Manager of Sales and Marketing for BlueScope's Coated Industry Products Australian division. He is well known as the son of former BHP chair Jerry Ellis, and has worked in BHP Steel in early 1990s. When Mr. Ellis was assigned as a general manager, it was a difficult time for Australian flat steel market, and he saw a substantial reduction in BlueScope's shares of Australian steel sales from 2008 to 2012, and the company was selling flat steel products it could not sell in Australia to overseas buyers at a loss. You may wonder why they had to sell at loss. This is because blast furnaces in which raw steel is created must be kept consistently firing while operation. Reducing capacity where demand drop is therefore usually uneconomical for producers. This means that mill steel production needs to remain relatively constant at all times. Mr. Ellis understood that BlueScope wanted him to be a savior and do his best to reverse that trend. He then promoted a price list to distributors and set up floor prices for BlueScope's products. He did so not by asking people to sign a contract, rather by including a consensus of medium minds of 7 main distributors, an overseas steel mill, and an import trader. He convinced those industrial competitors to adhere to the benchmark price circulated by BlueScope. This is called benchmarking strategy. For some of you that don't know, distributors for flat steels have wide discretion and offer particular advantages to their own customers. They could make arrangements for shorter delivery times, lower minimum volumes, and even provide credit facilities. They could also arrange processing services such as cutting, recoiling, and drilling. What Mr. Ellis did was listen to BlueScope's customers first. He collected feedbacks and learned that the distributors were frustrated that the discounts of BlueScope offered to some end users was undercutting them and made it not economically viable for them to compete in the market. Mr. Ellis then promised to them that he would soon arrange publishing price lists, and there would be an opportunity to use them as a benchmark when setting prices, to put value back into the flat steel market. This way, those distributors will leave some profitability behind. One such meeting was held at Melbourne Airport on 6 September 2013. And the other meeting with Taiwanese import trader was in Kaohsiung on 26 February 2014. For example, it transpired that Mr. Ellis openly said the following words during the Melbourne Airport meeting. There are 3 things that we need to do. 1. We need to find a way to increase our price. 2. We need to tighten our controls substantially around the tactical pricing. I want you to approve all tactical pricing offers. 3. We need to encourage the distributors to use the price list as benchmark when they are setting their prices. That is the way it used to work when I was at CMC. Mr. Ellis then circulated December 2013 benchmark spreadsheet containing recommended resale price and import parity price for each flat steel product. The prices in this new list were higher than previous ones, but it applies a larger discount in favor of distributors so that the net prices remain roughly steady and the margins for the products ranged between 13 to 15%. It is important to note that BlueScope and Mr. Ellis did not contest the existence of benchmarking strategy. And as we will discuss later, what in dispute is whether such strategy constitutes breach of cartel provisions. Under the active management of Mr. Ellis from September 2013 to June 2014, and after the flat steel price hit the lowest point, it started to recover steadily. In August 2019, the Australian Competition and Consumer Commission, being ACCC, began civil cartel proceedings against BlueScope and Mr. Ellis, alleging attempts to induce cartel conduct in the flat steel market. From October 2019 to September 2022, separately, Mr. Ellis was charged with obstructing ACCC's investigation and encouraging employees to provide false information. On 9 December 2022, in the federal court, Justice Michael Hugh O'Brien found BlueScope and Mr. Ellis engaged in attempted inducement of cartel arrangement through their conducts. On 29 August 2023, the federal court imposed the largest cartel penalty in Australian history, $57.5 million on BlueScope and $575,000 on Mr. Ellis. Both of them appealed to the full federal court. On 29 August 2025, the full federal court, constituted by Justice Whitney, Justice Brownwich, and Justice Haley, dismissed BlueScope's appeal and upheld the penalty. Section 76 of the Competition and Consumer Act makes it contravention to engage in conduct that attempts to induce another person to contravene cartel provisions or give effect to a cartel provision themselves. Under Section 45AD of the Competition and Consumer Act, a cartel exists when competitors agree to act together instead of competing, especially to fix prices, share markets, rig bids, or limit supply. Cartels harm Australian businesses and consumers by raising prices and restricting competition. Importantly, cartel law does not just target successful agreements. It also targets attempts to induce others into cartel arrangements, even if no agreement is ever reached. The legal focus is on intent and conduct, not just outcomes. Now let's look at what the parties argued in court. BlueScope and Mr. Ellis did not contest the existence of benchmarking strategy, nor did they object the goal of such strategy was to increase flat steel prices in the Australian market. The center of the appeal is the proper description and characterization of those strategies. Their key arguments on appeal include: number 1, the pricing strategy was just a benchmark or guideline, not an attempt to fix prices. Mr. Ellis said in his evidence that the guideline was served as a recommended price, which distributors can choose to take into account in their own pricing decisions. It's not the real floor price that fixes, control, or maintain the pricing for the products. Number 2, it never sought explicit commitments from counterparties, and none of the counterparties gave any commitment to the floor pricing. Also, there was no evidence showing that BlueScope offered any advantage in exchange for such commitment. Mere discussions of prices doesn't amount to an attempt to induce cartel behavior. It is natural that BlueScope did hope that the prices could be increased, but it was never its intention that any entities would really be committed to such best wish. Number 3, it's commercially impossible to fix pricing. Since distributors face a high degree of competition, they need to retain pricing flexibility to negotiate prices with larger customers, so it would not have been commercially feasible for BlueScope to dictate what they should use for pricing. What does the court say? The following observations made by the court really impressed me. Number 1, the intention and conduct are clear. The intention of BlueScope is that prices of products need to be increased. The conduct taken by BlueScope is trying to induce and understanding rather than a commitment. The benchmarking strategy was a significant project which continued for at least 8 months and involved numerous meetings. If BlueScope said it was not commercially feasible to have consensus, why initiate it in the first place and wasted significant time on something that was unlikely to happen? The steps taken by BlueScope are more than merely preparatory to bring about the intended outcomes. It has a fairly strong degree and content of persuasion for the distributors to do so. The fact that Mr. Ellis told one distributor that other people had already agreed to adopt the proposal, that they were not being asked to act alone, and that they would all be making money, increased the prospects of success and reinforced the ACCC's case. Number 2, commitment is not required. Mutual understanding is adequate. The legislation's intention is that it does not require any contractual obligation or commitment for competitors to agree on pricing. The word commitment has not been used by Parliament. To trigger the anti-cartel provisions, it only requires some sort of consensus, understanding, or arriving at a common mind as to price controlling and cost to be followed. What all matters is the conduct of BlueScope and representations made by Mr. Ellis arose expectations as to what they would do in the future. The court gives an example used by Justice Cross in the British Basic Slack case. One friend says to another, "I shall be dining at the club tomorrow night. Will you be there?" The other replies, "Yes, I will look out for you in the smoking room about 7:30. Either is free up to the last minute to leave a message with the hall porter to say they will not be there, and even if he forgets about the engagement altogether, it doesn't matter. Yet in the eyes of anti-cartel provisions, it could fairly be said that they had entered into an arrangement. That bar is extremely low. Importantly, the court notes that it is not necessary that BlueScope needs to reach the same understanding with all 7 distributors, overseas mill and import trader. Rather, it can reach separate understanding for each of them regarding price fixing. Number 3, inducement includes threats. It transpired in the trial that, coupled with the price guidance, Mr. Ellis made the threat that if the import traders did not increase prices, BlueScope would initiate anti-dumping complaints against them. So it is sufficient that the attempt to induce, including offering promise or threats or otherwise engage in persuasive conduct that is intended to induce a consensus. Number 4, commercial sense approach is needed. BlueScope saying that distributors need to retain flexibility and independent decision-making mean that price lists would never have been able to constrain pricing is wrong. It assumes as if all distributors were immune to cartel proposal. It assumes that no matter how attractive or lucrative the BlueScope's proposal might be, each distributor will behave as if they stubbornly refuse to take money on the table. This is against the commercial reality. Also, to be successful, a coordinated price increase requires all distributors to believe that their competitors will also raise prices. Otherwise, in a highly competitive market, raising price alone will suffer significant loss. Thus, in a market where a dominant player like BlueScope is trying to bring about a new pricing norm, an inducement to others is that BlueScope sending a message to everyone. Trust us, this is actually happening. You should increase your prices too. It takes a lot of efforts to get every competitor to believe each other. This is commercial reality. Number 5, degree of control is relevant only to penalty. Total control of pricing is not necessary to trigger anti-cartel provisions. There may be price fixing in the absence of agreement as to the price. BlueScope's control in this case was found to be the attempt to induce the counterparties to use the recommended resale price as a floor or minimum price for the rolled steel products. The distributors still retain a large degree of flexibility. That doesn't mean the market price is not distorted. The judgment stressed the conduct was capable of assent, meaning it was realistically capable of leading recipients to accept or adopt a pricing understanding. The focus was not whether assent actually happened, but that the conduct following such consensus would lead to contravention. BlueScope's use of recommended pricing lists and discussions about pricing with competitors was capable of leading to an understanding, contravening a cartel provision, even if no agreement was finalized. The judgment pointed to circulating pricing lists to distributors and an overseas manufacturer, encouraging use of the lists as a basis for pricing, and repeated discussions across multiple competitors. These factors all became evidence that BlueScope intended to influence pricing and thus was attempting to induce cartel arrangements. The ACCC has explicitly stated that cartel enforcement is an ongoing priority, including pursuing attempts to enter collusive arrangements even when no written agreement occurs. Since 9 November 2022, penalties for cartel conduct have increased substantially for corporations and individuals, enhancing ACCC's ability to deter breaches. The cap used to be $10 million or 10% of annual turnover, or 3 times the value of the benefit obtained, and it is now $15 million, 30% of turnover, or 3 times the value of the benefit obtained. Recent ACCC media releases show cartel cases are active, with new proceedings commenced regularly. For businesses, pricing discussions across competitors must be handled with extreme caution. Competitive behavior must be well documented and supported by independent commercial rationale. For directors and officers, this case also brings a deterring effect because it makes it clear that ACCC can seek a non-indemnification order against the individual if it knows that the large corporation maintains insurance to cover directors and officers' liability. When a director or officer plays a central, ongoing role in attempts to induce the price fixing, they may be held personally liable without ordinarily indemnification from their employer. BlueScope Steel's case marks a watershed moment for competition law in Australia. It shows that you can be held liable for attempts to shape competitor behavior without a formal agreement. It underlines that intent and influence matter just as much as written contracts. This case is not just about steel. It applies to construction, energy, retail, logistics, and any concentrated market under pressure. For the broader market, the ruling reinforces the ACCC's assertive enforcement posture, the broad reach of cartel provisions, and the need for robust competition compliance training across all sectors of the Australian economy. What do you think? Was that penalty too harsh for someone acting in what he believed was the industrial survival interest? Or is this exactly the kind of punishment needed to send a clear message that competition laws don't bend in a crisis? And if you were in his position, responsible for thousands of jobs facing collapsing prices, what would you draw the line? Let me know your thoughts. Don't forget to like, subscribe, and hit the bell for more legal explainers. Thanks for watching. See you next time.